Right, good afternoon everybody. This is Grant Kaplan. It's been a while, but as you can see, contrary to popular belief, I'm still alive and we're still good over here. As many of you know, we run an all-embracing immigration law office. We cover the full spectrum of immigration. We love to assist people in all fields of immigration. We're available 24 hours for any kinds of emergency. We cover all aspects of immigration, from business immigration, removal, asylum, green cards, naturalizations, whatever part of the alphabet soup of immigration you guys can think of, we will cover. We do this with joy and with happiness because many of us are immigrants. You can hear by my funny accent perhaps. Any guesses from where I am? Those who do not know me gets a special prize. Also, we are live, so I'd like to see on the screen, when I go to my screen, to see that you guys are present and available. Send us a couple of smiley faces, send us any comments that you want. This is an interactive session, so of course, looking to see that you guys are coming in and that you're helping us. So I can see over there, the people are starting to log on pretty actively, so that's a good thing. And looking forward to having this discussion. Today we're going to be discussing family-based green cards, marriage-based derivative visas, abuse claims, any way that you could get a green card and therefore citizenship through family, through derivative citizenship. So we're going to be discussing all of that as we go along. This is quite an all-embracing topic, and I'd love to see any kind of comments that you guys might have as we go along. I have a couple of questions that have been posed to me, which we're going to certainly talk about, and we can get started as we go. Again, if you need to email us or you want to check us out at any time, with absolute pleasure, the office telephone number +1 561 347 8440. That's +1 561 347 8440. The website is usvisasandgreencards.com, and you can email us at any time at info@usvisasandgreencards.com, and we look forward to that. There is no charge for consulting with us, to telephoning us, to letting us know what it is that you guys have in mind, and we'll certainly go and have a look. Let's just go and see who's having a look at us today. Tanzil is there from Johannesburg. How are you doing, Tanzil? Mohammed, how are you doing? And then we've got Makanzu, and we've got various others. Hello to all of you guys. Any specific questions that you have, please put them on the screen, and we'll be happy to help you guys as we go along. Let's see how we're getting on over here. Let's begin by discussing who can get a visa through family and how do you get these visas. Let us start with marriage-based visas. If you are in the United States and you are eligible to change your status, which we'll discuss in a short while, a U.S. citizen spouse can file for you. And nowadays, under U.S. immigration law, this also includes same-sex marriages. And believe it or not, the Immigration Service has got specific sensitivity training to train to deal with same-sex marriages. I've been with many of our clients to these interviews, and believe it or not, as they say, Ripley's believe it or not, they are in fact somewhat sensitive and treat same-sex marriage cases on a more sensitive basis than any others. My own belief is that many of these immigration officers don't have any warm blood, as I say often to our clients. They're very bureaucratic, and they will do whatever they wish to do. Having said that, if you are in the United States and you've come in with a visa, and it is not a restrictive visa, it is theoretically possible to change your status, whatever the status that might be, by virtue of your marriage in good faith to a U.S. citizen, to obtain a green card. And that is done by filing what is known as an alien relative petition. and at the same time filing an adjustment of status petition together with all the supporting documents that one requires. And again, we'll certainly be happy to help you and to file all of these with pleasure. Let me just see if anyone has anyone from on that particular aspect. No, I think we're all good on that particular subject. There are comments for various others, and we'll go from there to answer those with pleasure. There is something called a 30, 60, 90-day rule in the United States, which means that if you came into the United States, for example, as a tourist, or if you came in as a student, or if you came in under any other non-immigrant visa other than that which is restricted, for example, a J1 visa, which we'll talk about separately, it is possible to change your status in the United States. However, when you come into the United States, you need to come in with the intention created for that particular purpose. So if you come in with a tourist visa, supposedly, your intention must be to come in and visit on a brief, innocent, and casual basis. In other words, you must be coming in for the purposes of having a holiday. Of course, once you're here, you can certainly change your intention and decide that you wish to marry, that you wish to stay, that you wish to become a student, whatever it might be. And that being the case, you can certainly change your status. And that is where the 30, 60, 90-day rule comes into play. The Immigration Service believes that if you change your intent within 30 days, then your intent was in fact preconceived, and you came in with the intention not to be a tourist or a student, whatever the case may be, but really that you intended to marry and change your status. So nowadays they're tending towards more than 90 days rather than the 30-day rule to change that presumption. And most of our clients, we advise them that they should not be filing anything prior to the 90-day period, or in fact even marrying, if they intend to change their status at all. If you come in, for example, with a J1 visa, a trainee visa, and that visa requires you to return to your country for a period of 12 months or 24 months after your period of training has been completed, it is possible to obtain a waiver in the United States so that you can in fact change your status. And anyone in that position, certainly you guys can call us as well. We will be happy to help any of you guys in any kind of position. Many guys come in without inspection. In other words, they come in without visas for whatever reason. And those people typically cannot adjust their status in the United States. And we'll discuss that separately, but there is something known as a stateside waiver, where it is possible to obtain a waiver in the United States and go back to the U.S. consulate in the country from which you came in order to do your adjustment. So, who can file for you as a non-citizen? If you are the spouse of a U.S. citizen and you came in with a visa, as we've discussed, then certainly you can do this. If you are the parent of an adult child that is a U.S. citizen, in other words, above the age of 21, then certainly you too can adjust your status in the United States. I hope you guys are enjoying the video so far and my presentation. If so, please send us a couple of smiley faces, send us some love, not the middle finger, but any other finger will do. Hopefully a thumb or so. Let's have a look and see. I see there's hand clapping from various people, even hearts, so that's encouraging to see, and that's a good thing. All right, so we're talking about marriage-based visas. We're talking about who can apply. So if you, to summarize so far, if you've come in and you're in the United States in any basis, even if you've overstayed your status, if you've come in, say, for example, on a tourist visa and you've overstayed, it is still possible under our law to get an adjustment of status, in other words, a green card, through your U.S. citizen spouse or adult U.S. citizen child, and obtain your green card. So in most cases, the Immigration Service will forgive the overstay and allow you to adjust, even if it might be months or years. We have had very interesting cases. We had a guy once who came in to see us. He must have been about 50 years old. And he was of the belief always that he was a U.S. citizen, and for whatever reason had never traveled out of the United States, and one day went to apply for a passport, and when he went to look for his birth certificate, he saw that it was a Canadian birth certificate. And what had happened was, when he inquired of his mother why he had a Canadian birth certificate and not a U.S. birth certificate, was that in those days, apparently, his family lived in Buffalo, New York, and his mother believed that there was better medical treatment, certainly maternity-based treatment available in Canada, and she went across the border to give birth to him and returned back to the U.S. 2 days later. So his whole life he had believed that he was a U.S. citizen until 50 years later when he discovered that he had not. Fortunately for him, he was married to a U.S. citizen, and we filed for a green card, and he managed to obtain his green card, and life went on, and all was good. So just goes to show, you just never know your circumstances, and I'm sure many of you have stories which you may want to share with us, and by all means, please, send us on the screen, and we can have a look and see how to proceed. One question is from Brent. He says, my brother and sister live in the States, and how can he and his wife now get an adjustment of status? Brent, the unhappy news is that sibling-based petitions, although are still being permitted in U.S. law, that's unfortunately in a fourth preference category, and will take about 13 years under current processing times. So certainly your sibling can file for you and should file for you, and you will go in a line to wait under a future immigration dispensation, by the way. This category is probably going to be done away with under the so-called chain migration, which is proposed. However, if you've already filed that, presumably you would be grandfathered in, and therefore that application would be sped along, and hopefully you would wait a lot less than 13 years to get yourself right. So that's as far as sibling petitions are concerned. You guys should understand that there are various categories, preference categories in immigration law as to how people are categorized in terms of where they fit in other words, how long you need to wait to get a green card. So first preference categories are parents of adult U.S. U.S. citizens, spouses of U.S. citizens, and children under 21 who are not married are going to a first preference category. There are various other preference categories from there, second preference and third preference categories, and so on. Typically, you need to be a U.S. citizen to file for a beneficiary, but not in all cases. Permanent residents, in other words, those people who have got green cards, can also file for children and also for a spouse. Those are not immediate, and therefore the beneficiaries have to wait in line until such time as their preference categories are reached. And if you, for example, are filing for a child over 21, that wait might be 5 or 6 years. So unfortunately, there are waiting times for large numbers of guys. However, if you have nothing else, certainly it is beneficial to file for that. Now, let's see whatever else is going on here. Natasha says she's in New York, she's got a visitor's visa, she became illegal, got married to a green card holder. Can she petition for him? Can he petition for her? I'm sure that should say. Yes, he can. As I was saying, a green card holder can petition for his spouse, the I-130 petition. Unfortunately, that doesn't give you an immediate green card. You go and wait in line. Currently, the wait may be 18 months to 2 years, and that doesn't allow you to adjust in the United States until he becomes a U.S. citizen. And so once that time comes and he's not become a U.S. citizen, that means that you may need to go and get your green card at the U.S. consulate and also file for a waiver for the overstay. So of course the obvious follow-on to that was that if he's close to becoming a citizen, he should certainly file for his U.S. citizenship, and the day he becomes a US citizen, he can then file for your green card. But in all of these cases, give us a call, and we'll be happy to chat about that. There's no charge to call us or to email us. Again, our telephone number +1 561 347 8440, and our email info@US Visas and Green Cards. I'll be happy to take any more comments that you guys have. I see Tennis is writing. He says his parents are US citizens. They applied, or presumably they applied for him in 2016 with an I-130 petition. He's over 21 and unmarried, and he wants to know, will that be possible? Will that be done away with under chain migration? It may be, but that doesn't affect you, Tennis, luckily for you, because that's already been filed, and you should be good. Again, Tennis, give us a call, 561 347 8440, and we can certainly talk about that and see how we go. Monica also has an inquiry. She wants to know if she's got an L1, can she apply for a green card? Certainly you can, Monica, either through the business itself or through some other basis for which you may be eligible. And again, give us a call, 561 347 8440, and we can certainly talk about that. So that's the story over there. Let us proceed now to discuss who else can get green cards. If you are a US citizen and you wish to file for a fiancé, in other words, you have a relationship with somebody who's not in the United States, you can certainly file for them. Doesn't matter where they are in the world, and that process typically is filed for initially in the United States. Once approved, goes through the National Visa Center out to the US consulate that your fiancé may be resident in, and from there they will have an interview. They want to know that you have a good faith relationship. Of course, you need to have met your fiancé. Many guys contact us and say that we haven't met for whatever reason. That's unfortunately not going to fly. You do need to have met. You do need to have proved that you have a relationship, that you've known each other for some time. And once that visa has been approved, that allows your fiancé to come into the United States, and you need to marry within 90 days. And from there, you can file for a green card. There is a very popular show on TV at the moment, which my wife seems to be fascinated with, called 90 Day Fiancé. That is a show typically which typifies this exact situation, where the US citizen typically has a relationship with someone that they wish to bring in from all corners of the world, and they need to cultivate that relationship and marry within the 90 days. So once they come in, we file the adjustment of status once they marry, and the guys get green cards from there. Certainly we're able to help with that, and we'd be delighted to do that. Give us a call, 561 347 8440, or email us at info@usvisasandgreencards.com. All right, so now let's look and see who else there is over here. There is an inquiry from someone, cannot clearly make out his name. I think it might be Muhammad. Wife and kids are living in the US. They've applied for his visa, but he's a refugee now living in South Africa. The same principle applies. When the priority date has been reached, then you can go in and you can go and get your green card, I'm guessing, at the consulate in Johannesburg in South Africa if you're resident there. If you're not resident there, you'd of course need to go back to the US consulate in Somalia. There's another inquiry here from Ravine. Ravine says, I'm an asylum seeker. I'm married to a green card holder. She filed the I-130 for me that got approved. Can I apply for adjustment of status while I'm in the United States as the spouse of a green card holder? And the answer to that is, if you're deemed to be in status, in other words, if you're in status in the United States, at the time that your priority date is reached, then you can adjust your status in the United States. And if you're not, then you'd have to go out to the US consulate closest to where you are. Your case is particularly interesting because you're an asylum seeker, so we would need to determine whether you're in status or not in status. And then the second difficulty is you'd need to determine whether you could go back to your country to go and get the green card if you're seeking asylum. So easiest solution for you is to give us a call. Give us a call, please. We can certainly chat about that. 561-347-8440, or email info@US Visas and Green Cards. We were talking a short while ago about chain migration. What's next? It's anybody's guess. We don't know what's next. The priority categories are all over the place. Some countries' citizens are backlogged. If you come, for example, from the Philippines, from China, from various other places, you might find that you may be backlogged as much as 10, 15, 20 years in some cases. That is, of course, unfortunate, and we need to obviously have the whole of immigration, as a matter of fact, fixed as soon as possible. There are various other ways for people to obtain green cards through family basis. We deal with many abuse type cases, unfortunately, where the immigrant, the beneficiary of a visa, comes into the United States and marries a US citizen and is taken advantage of, either physically, mentally, verbally, whatever the case may be. Those people can claim under the Violence Against Women Abuse Act. These are confidential applications. The US citizen never gets knowledge that the person is filing for this. You need to show two things. You need to show, firstly, that you married in good faith, of course, and secondly, that you've been subjected to some kind of abuse, whether mental, physical, verbal, whatever the case may be. We do many of these cases. We're largely successful with them, and certainly we can help you. Just an offshoot of that, there are other visas going through the alphabet soup, like U visas, if people are victims of crime. Certainly they can file if they assist the police in their investigation. And there's various other claims to derivative citizenship. If your parent or your grandparent, for example, was a US citizen and they lived in the United States for a certain period of time, you may be eligible to get US citizenship, even though you may not be aware that you have US citizenship. May be possible to certainly apply. Again, give us a call, +1 561 347 8440, and our email address info@usvisasandgreencards.com. Let's have a look and see if there's anyone else who's got any inquiries. We've got something here from James. He wants to know, how long does it take if your father is a citizen can apply for a green card for you? On the assumption that you're over 21, and whether you're married or not married will determine how many years that is. Probably could be anywhere between 5 and 6 years, depending upon the country that you come from, in order to determine that. There's something else here from Hamid, who says he's done his fingerprints in June 2017. He's still not got an interview at the appointment for his appointment in Chicago, and he wants to know what's going on. With anyone who has filed applications, of course, you can at any point make what is known as an info pass appointment and go to the closest US immigration office by making this appointment and see an officer at that appointment to find out exactly what is going on with your case. And you can even ask for a supervisor to come across. The advantage of doing that is that they will investigate, can send an email to the officer that's physically adjudicating your case, and you can get something going from there. We deal also with many people who have delays in their cases for various reasons, and they're typically given answers like we're doing background checks or we're doing whatever it might be. Of course, if you call us or email us and you retain us, we can certainly follow up with the supervisor. We can even file applications with the federal court if necessary to file some kind of mandamus action to compel them to get on with it. It cannot simply lie in someone's office for years on end. And again, if this is you or maybe someone that you know, by all means give us a call, +1 561 347 8440, and we'll certainly be able to help you. Many times people, there's something here from Malik who asked the question, can he get a visitor's visa to visit a relative in the US? many times, and we'll talk about consular processing on another day at the consulate, but many times people go and apply for a visa at the consulate, and they have a U.S. relative in the United States, or they believe, the immigration believes they're going in for a purpose other than to be a tourist in the United States, and in that case they deny the visa application. We'll talk about consular processing on another day, but of course you need to be able to show that you intend to return, that you've got ties to your home country, and so on. So certainly that is the story. As far as the travel ban is concerned, we have had cases with clients who have got spouses in Iraq, Iran, and various other places, and they cannot travel for various reasons. In these cases, typically, in order to process these visas, they typically send out the interviews to other countries like Turkey, could be the United Arab Emirates, something like that, where they could have their interviews and they could be granted their green cards and come into the United States. So the fact that you or your fiance or your spouse or your child is from one of those countries does not necessarily mean the end of the road, and I'm happy to discuss each of these cases with you with pleasure. Again, let me tell you our telephone number, +1 561 347 8440, and our email address, info@US Visas and Green Cards. So that's really where we are as far as that is concerned. Derivative citizenship, very interesting topic. What's going to be happening in the new dispensation, we're not sure. My advice to all of you is that if you have a petition waiting to be filed, that you get on with it, you file that as soon as possible, and rather have that sitting at immigration, no matter how long the wait may appear to be. Get it going, guys. That's what you need to do. We'll be happy to help you with this, and look forward to hearing from all of you guys and to assisting you. As you can see, this is a very relaxed place, and we'll be happy to help all of you guys. We work in teams over here, and we will hold your hands through whatever you may be going through. Many of our clients have been through the process themselves, and we'll be happy to help you because they have been through the process themselves. Thanks very much, guys. I look forward to hearing from you, and to please continue to send your messages through, your hearts, your arrows, as long as they're not attached to bows with arrows. Any other affection we'd love to see, and any queries or anything else that you might have, we'd be love to answer you. Looking forward to speaking to you guys soon. Thanks. Cheers.